Kerry, turn it over to you.
Thanks, Jay. Appreciate that. Good morning, ladies and gentlemen. Thank you for the invitation. Brandon and I are honored to have an opportunity to appear before the Tuesday Club. And we look forward to engaging in a interactive educational program this morning. As I explained briefly before we went live to a number of the program chairs and the leadership of the organization, I'm embroiled in an emergency elder abuse case this morning. So my son and partner Brandon and I are going to do a team teaching approach here to the speech, because I will eventually at some point get called out of the speech to attend Zoom court. If you don't know, you should know the Circuit Court of Cook County, the largest unified court system in the United States, has been operating since shortly after the pandemic hit in the spring of 2020 on Zoom. And we literally go to trial on Zoom. We appear in court on a regular basis. And the technology has allowed the court system to, in some instances, move along relatively well, and in some instances, overcome the challenges of the continuing pandemic. Obviously, you're familiar with Zoom because we're appearing today, and the Tuesday Club appears by Zoom on a regular basis, as does many of the Senior Center events. We are honored and privileged to be the official law firm of the North Shore Senior Center. And we've worked with the Senior Center for many, many years in a variety of capacities, and look forward to a continuing relationship. So today we're going to talk about elder abuse. Regrettably, I'm here to tell you that elder abuse is an epidemic. It is an extraordinarily serious problem. It hits older adults in the pocketbook, it hits them in the head, and it hits them in the heart. Why? Because when an individual suffers from elder abuse, they're 300 times more likely to die an early death. And that's rather stunning, but the National Council on Aging tells us about that. And as Jay mentioned, some years ago, I was engaged in the law firm to rewrite the state of Illinois Elder Abuse and Neglect Act. And what that meant was that we drafted legislation. We met with members of the House and the Senate here in Illinois. I testified before the Senate and House committees, and ultimately that legislation was passed, and the governor signed those new laws some years ago. And we're going to talk today about some of those laws. We're going to talk about some recent laws that have been added to protect older adults. So, Lauren, let's take it away. So, dishonest people plus some type of cognitive impairment yields financial exploitation. And of course, dementia comes in a lot of different forms. It comes certainly from Alzheimer's disease. It often comes from a stroke, comes from Parkinson's disease, and maladies of that nature. But when an individual is cognitively impaired and even slightly, and they run up against somebody that's dishonest, they are very likely to fall prey to some type of financial exploitation. And of course, that financial exploitation comes in a lot of different forms today. Certainly, internet exploitation is one of the most prominent. We hear stories all the time anecdotally about people getting phone calls, the Nigerian Prince lottery. You won the lottery in Nigeria, send us $1,000 to pay the taxes and fees and we'll send you $1 million. Okay, obviously that's a scam. It's not going to happen. But these are real live problems that occur every single day, and thousands of seniors, millions in fact, are exploited on a regular basis. Next slide, please. So if we rely on the statistics from the National Council on Aging, you take a look, how many older adults are abused? Well, they estimate 1 in 10. That's just like stunning. 1 in 10 older adults have experienced some form of elder abuse. Some estimates range as high as 5 million elders abused every year. And one study estimates that only 1 in 14 cases of elder abuse are reported to authorities. Typically, elder abuse is not reported. Older adults are humiliated, they're shamed, and many older adults that are on their own don't want their families to know that they've been abused, because the family's response is, of course, if you can't take care of your own money and your own finances, you probably have to go into a nursing home. So that's a real problem in terms of underreporting of this serious crime. So who abuses older adults? Well, regrettably, abusers are both male and female. In about 60% of the elder abuse incidents, the perpetrator is family. So another horrendous scenario in the world of elder abuse: your loving family is looking to get into your pocket and into your wallet and into your bank. And this is a very, very serious problem. National Council of Aging reports that 2/3 of the abusers are adult children or spouses, even a little harder to believe. So, the next question is, what makes an older adult vulnerable to abuse? The number one issue: social isolation. So stay active, stay engaged. And of course, some type of cognitive impairment that I mentioned at the outset of our presentation. Recent studies show that nearly half of those people with dementia experienced some type of abuse or neglect, and that interpersonal violence occurs at a disproportionately higher rate among adults with disabilities. So this is a continuing problem. This is a nationwide problem. We should not think the North Shore is exempt from this problem. We are not. I can tell you that we are involved in many, many elder abuse cases in the northern suburbs on a regular basis. So what are the effects of elder abuse? Well, as I mentioned, elders that have been abused have a projected 300% higher risk of death compared to those that have not been mistreated. And while elder abuse is likely underreported, both financially and fraud, it's those that are, it's estimated it costs older Americans $36.5 billion with a B per year. And yet, obviously, for the reasons that I mentioned, it's not really reported that much. So what is elder abuse? Well, elder abuse comes in a lot of different forms. It includes physical abuse, emotional abuse, sexual abuse, exploitation, neglect, and abandonment. Lauren, would you please move to the next slide? Thank you. And let's move ahead. So we're going to now evaluate elder abuse in the context of a hypothetical we've created.
So the hypothetical goes as follows. Charlie and his wife Patty have been married for 40 years at the time of Patty's death a year ago. Charlie was CEO of a large company, received a generous compensation package when Patty passed and he retired. 2 months before Patty's death, Charlie suffered a stroke and was hospitalized. Charlie's mental capacity was affected by a stroke, as well as his ability to walk more than a short distance. He immediately enrolled in a stroke rehabilitation program at the local hospital. After Patty's death, Charlie continued to live in their Chicago condo on his own while handling all of his personal and financial affairs. Charlie had no children and only one sister, Sally, but she had never been involved with his financial affairs and lived far away in California. She was aware, however, that she was named his successor agent after Patty under his healthcare and property powers of attorney that Charlie had signed 5 years earlier when he updated his estate plan. When Charlie began his rehabilitation program, he met a young, attractive personal trainer, Amber, who was assigned to assist him. Amber had six-pack abs and a 7-year-old daughter. After Patty's death, Amber took a special interest in Charlie. One day after rehab, Amber asked Charlie to help her replace a light bulb at her nearby apartment. From then on, Charlie's handyman skills resulted in frequent visits to Amber's home after rehab sessions. Soon after, Amber asked Charlie to co-sign a car loan so she could get a new Audi SUV. Charlie readily agreed. Eventually, Amber and her daughter stayed at Charlie's condo more than at their own apartment. 5 months later, Amber suggested that Charlie execute durable powers of attorney, naming her as the agent, since Patty is no longer able to help, and she was right here in Chicago, and not far away like his sister. Charlie agreed and was immediately swept away by Amber to a nearby attorney who had previously been contacted by her. He had already drawn up the powers of attorney for both healthcare and property based on information provided by Amber over the phone. During the brief office visit, the attorney asked if Charlie wanted to appoint Amber agent for both healthcare and property decisions, to which he said yes. The next day, Amber changed the beneficiary on 3 of Charlie's life insurance policies from Sally to herself. In the next several months, Amber withdrew large sums of money from Charlie's bank accounts, using $450,000 of his assets to purchase a lakefront vacation home in Michigan, $20,000 of his assets to purchase savings bonds for her daughter, and $75,000 of his assets to pay off her Audi SUV. Later in the week, Sally got a call that Charlie was in the hospital. She immediately flew to Chicago to visit him. At first, the hospital staff refused to discuss the situation because someone else was power of attorney. Sally produced a copy of the power of attorney created 5 years earlier so that they would share information with her. Still, they considered Amber to be the agent with authority to make healthcare decisions since the power of attorney naming her had been signed more recently. Charlie's sister arranged a consultation with an attorney to discuss her concerns about Charlie and what could be done to protect him from financial exploitation.
So these are the kinds of situations that we see on a very regular basis. In this instance, the alleged abuser is the trainer. We see a lot of circumstances in which the abuser is a caregiver, left alone with an elderly gentleman. And one thing leads to the next, and all of a sudden he's signing documents, giving her the house, giving her his bank accounts, things of that nature. And much like the situation here with Charlie and Amber, all of a sudden, I call these cases love at first sight of his wallet. That's what this is really all about. So let's move to the next slide, please, Lauren. And before we go to the new federal law, in the hypothetical with Charlie and Amber, typically what we would do in these kinds of cases is we would have, if we can, get Charlie evaluated for his mental capacity. And many times, 99 out of 100, the doctor will conclude that Charlie is not able to manage his affairs, and we will go into the circuit court of either Lake County or Cook County, certainly the North Shores of Cook County, other than obviously up Lake County, Highland Parkway, and ask that a temporary guardian be appointed. And we'll talk about that a little bit later. That temporary guardian would be a judicial determination that Charlie needs a guardian to make decisions for him and basically freeze his assets. Okay? We want to freeze his assets so that Charlie has the money for his own health care. Because I can't tell you how many cases we've been involved in which we get the call too late. The horse is out of the barn. The money is gone, and the abuser is often on an airplane back to Eastern Europe on a regular basis. Boom, gone. So should you become aware that a family member, a loved one, a friend may be the subject of exploitation, jump on it. Don't wait. Don't not get involved, because these cases move at a very rapid pace. The abusers are in the situation very quickly, and they want out very quickly. It's a hit and run for money on a big scale very quickly. We were involved in a case in which a fellow lost his wife. He went to church to mourn her loss. And the third week after she died, a woman, a very attractive young woman, sat down next to him. And again, I call it love at first sight of his wallet. And the first week she knew him, she took him to his stockbroker, his accountant, and she moved in to the marital home. Bingo. Instantaneously seeking access to his money. So these cases, as I've said, they move at lightning speed, and it's imperative that you get in a lawyer that knows what he or she is doing immediately, because speed is critically important to offset the abuse, which is moving again at a very rapid pace.
To add one thing, as Kerry said, our first step is typically going to be to get a medical exam to, as he said, 99 out of 100 times indicate that Charlie would not have capacity to make these decisions on his own. We know that some of the wrongdoing has happened, but as Kerry stressed it, we want to get in as contemporaneously as possible so that the medical report is timely and that we are not in a situation of asking the internal medicine or psychiatrist to roll back the clock more than maybe a few weeks, a couple months, so that the medical records and their analysis will support that the individual lacked capacity going back to the transactions at issue.
The law in Illinois requires that if we go in and ask that someone be declared a disabled person and that they have a cognitive impairment affecting their ability to make their both health care and their financial decisions, the law requires that the medical report be written and based on an exam not less than 90 days before the case is filed. So as Brandon pointed out, the medical evidence needs to be contemporaneous with the ability and with the action to go in and protect this older adult. Again, protect this older adult from making their bad decisions as a result of an impairment, and make sure they have the money to pay for their own health care, to pay for their own living circumstance. So that's very important. So let's move ahead to the new federal law.
Kerry, we have a question.
Okay.
There's actually two. I'm not sure about the first one. The first one is, as the executive director of the Jewish Child and Family Services, I was a mandated reporter for child abuse. Was I also mandated to report suspicions of elder abuse?
Well, in Illinois, most everyone that holds any form of a license that's issued by the state of Illinois, so that could be literally a cosmetologist to do your hair, a podiatrist to take care of your feet, and everything in between, social service workers and the like, are mandated reporters. The only exclusion and exemption to mandated reporters are lawyers based on confidentiality and bankers who fought like hell to prevent them from being mandatory reporters. And of course, bankers are uniquely situated because more often than not, an abuser either is going into the bank or getting access to someone's funds via their financial institution. So generally, anybody holding a license issued by the state is a mandated reporter.
Okay, and then we have a question from Ron. How can I correctly get involved should I become aware of what might be elder abuse of someone who is not a family member? Who should I contact, and does the Senior Center offer guidance and direction?
Yeah, that's a great question. The answer is the Senior Center runs what's called an Adult Protective Services Unit. APS is the acronym, Adult Protective Services. And you want to reach out to the Adult Protective Services Unit at the North Shore Senior Center and report that elder abuse if you believe it to be true. If you report in good faith, you're totally immune from any wrongdoing. And so that's significant. And if you call the Senior Center, the process is that they employ very capable social service employees, social workers, and they will send out a social worker to literally knock on the door. Knock, knock, hi, we're the Senior Center, we're Adult Protective Services, and we'd like to talk to you, Mrs. Jones, about a report that you're being abused by the local handyman, or you're being abused by the local, somebody else. And in many instances, it's a terrific way to kick off an investigation. And it really is, in Illinois, is about the only way you can do it other than dial 911. And in general, you won't get a great response from 911 because they deal with exigent circumstances. So your entry point is the Adult Protective Services at the North Shore Senior Center. And that's really, I've had the pleasure, we've had the pleasure of representing them in a number of courtroom situations, very capable, competent people, and I would urge you to call them. Any other questions at this point, Laura?
No, all good.
Okay. So one of the things that you can do to protect yourself from financial exploitation is when you open a new account, or you can call your financial institution today and say, I want to add someone, I want to add a close relative, a close friend to my account, not to access my money, but to be what is called a trusted contact. So for example, if I have a stroke and I'm not able to manage my affairs and I'm not able to respond to bank inquiries regarding my assets in the bank, they are entitled to call my son. He does not have to be an owner. He does not have to be a signatory. He can merely be the trusted contact. And it's a terrific new innovation in the law that allows the financial institution, basically the cover, okay, to engage in confidential conversations with someone else about your money, all within the context of the law.
What this kind of expanded upon, as people may be aware, for financial accounts, you know, checking, savings, brokerage accounts, often you're able to grant individuals view-only access of the account so that they can view the transactions and see what's going on. But up until changes like this in the law, they would not have been able to discuss anything they saw with the financial advisor. Now, this gives, as Kerry said, the financial institution the cover to discuss that with them. And then, of course, they can discuss it with the principal owner of the account, whether it's their friend or relative. But they're not just kind of stuck or hamstringed by viewing it and not being able to have, you know, the, again, contemporaneous information from the financial advisor.
So let's move ahead, Laura. So we've pretty much discussed this. A trusted contact is the person you rely on. You can use it with your bank accounts or your brokerage accounts. It's a good idea to pick someone other than the joint tenant that's on your account, because it kind of expands the ability of the bank to engage in communications for your protection. Next slide, please.
Sure. So this is more recent. Stanley, who was the co-creator of many fictional superheroes, died in late 2018. The story goes that seemingly he took a downward turn after his longtime wife passed away the prior year in 2017. His manager, Miss Morgan, forced him to record videos that were later published online, speaking highly of his relationship with her and putting down claims that there's anything questionable going on after April of 2018, in which his well-being was put into question. In 2018, a restraining order stated that Ms. Morgan prevented him from seeing family and friends, trying to control his money and business affairs. In 2019, felony charges of theft, embezzlement, forgery, fraud were filed against Ms. Morgan for claims against an elder adult, and false imprisonment were charges were filed as well. Misdemeanor count alleges elder abuse. So in this instance, as we've kind of said, Stanley was, married for a very long time. When his wife passed away, his longtime manager, unfortunately, saw a vacancy and saw an opportunity to insert herself in that position and insert herself in order to receive the benefits that were previously being provided to his wife should he have predeceased her. Luckily, in this situation, because he was a public figure and because videos had been put forth, people were able to tell that he was having some cognitive decline and bring the appropriate parties in to help him. Mainly, it was brought into the court system and to the police. But the kicker here is that, he was a public figure, which allowed a lot of people to see what was going on and help him out. That's not the case with everyone. We only hear about, the highly publicized, the Britney Spears, the Stanleys, the Ernie Banks, those we'll talk about. But that doesn't change the fact pattern, and it doesn't change the remedies that exist for everyone's relief.
Okay, we have a couple of questions. Bob asks, if the abuser is a medical professional, is it of any value to contact the professional registry?
Yes, definitely yes. Again, you can make the report to Adult Protective Services. They can contact the accreditation department for the medical providers, whether it's the American Medical Association or someone else. It's definitely worth doing. Again, if you're doing this in good faith, there shouldn't be any backlash. But you want to make the parties aware that this individual, again, if they're doing it to one person, odds are this is not the first time, and you may be helping others around you.
Just contact the Department of Professional Regulation, State of Illinois.
Okay, we have a question from Don. He asks, what is a typical example of physical abuse?
Typical physical abuse is often beating people on their legs so that nobody can see the bruises when people put on pants. And that's often I guess, a common physical abuse scenario.
I think the other most common physical abuse that kind of changed a little bit is the isolation aspect. If someone is elderly and they have some type of physical impairment in which the exploiter can isolate them, physically isolate them, in their home, not prevent them from taking their car, not prevent them from getting on the train, not calling a taxi. We believe that probably constitutes physical abuse as well.
Great.
Lou asks, when a social worker comes knocking, do you allow someone else in attendance during the interview?
I think that it depends which side of the equation you're on. If you're hoping to prove that the abuse is occurring, then the answer is you probably want somebody to corroborate the abuse. Regrettably, there are circumstances in which the abuser interferes with the interview. So, kind of really depends whose ox is being gored. Those interviews are not recorded. And so, they regrettably, I think, saying again, can be interfered with. It depends if you're trying to support it or oppose it. Anything else there?
Not at the moment.
Okay, let's move on. So one of the, and it appears to be, it's certainly controversial. The question is, was Ernie Banks abused? And by all accounts, he was, to the extent that he was cut off from his family and a new estate plan was done for him. And I just got a message that I need to leave for this emergency elder abuse court appearance down the hall. And I'm going to turn the floor over to my partner and able colleague, Brandon. Excuse me. I'll be back when I can.
All right. So continuing on with Ernie Banks, I'm sure some of you heard the case. This was a very, very publicized proceeding in the Circuit Court of Cook County. This took place in the decedent's courtroom. So the documents, in this case, unfortunately, did not come to light until Ernie passed away. What did come to light then was that 3 months before he passed away, new documents were created giving his caregiver everything and excluding his family from his will and trust. The facts were that the caregiver prevented his children from speaking to Ernie the last few months of his life, and that based on the isolation and seclusion, the caregiver had the opportunity to create these new documents. So what was a big issue in this lawsuit in front of a decedent's judge was that when did Ernie's dementia start? How significant was it? And how did that weigh into when he signed the new documents? So as Kerry and I said earlier, the concept of the first step being that we need a medical report and that we want the medical report to be as contemporaneous as possible, along with any allegations of wrongdoing. That supports a case should it go to court whether it be in guardianship and the individual is still alive, or whether the case is in the decedent's estate and the challenge is being made after that individual passed away. The opportunity exists, and we have done this many times, that you essentially have the concept of a forensic accounting applied to medical. So you can hire experts, mainly psychiatrists, who will do a forensic evaluation of an individual's medical records and then give their opinion as to when they believe that individual lacked capacity to execute powers of attorney, to execute a new will, to execute a new trust, to change the beneficiaries of their bank accounts. And they will go through, just like anyone else, and review hundreds and hundreds of pages of medical records and talk to witnesses if necessary, come up with their forensic evaluation of when at this point the individual could not make decisions. So in Ernie Banks' case, there were substantial records of when the dementia kicked in, and it helped to lead to a resolution amongst the caregiver and the family. Lauren, could we flip to the next slide? So Mickey Rooney was another very publicized situation. He and his wife unfortunately had food and water withheld by their stepson in order for the stepson to gain control of his financial affairs, which is obviously despicable behavior to begin with. This would not only constitute physical abuse, this would obviously be a violation of the law in many instances. The son purportedly got away with over $400,000 that was taken to him. In addition to withholding food and water in this case, he withheld Mr. Rooney's mail, his IDs, his passports, and then he was told that he didn't need these things, that it was none of his business. So again, as we talked about, it's not only here, we have the physical abuse, but we have the fact that he was restricting his ability essentially to leave the home and leave, the pressure that the step didn't have his passport, he didn't have access to his money or his wallets. What was he really going to do? He could leave the home maybe, but he wasn't going to get very far without anything personal or the ability to use any of his assets. So again, this is another highly publicized case, but it's worth noting that these are examples of fact patterns that people are aware of, and whether it's highly publicized or not, the remedies are going to remain the same. Laura, we can flip to the next one. So warning signs of financial exploitation, and this is obviously not all encompassing, but these are ones we see with large frequency, we'll say. Investment advice. Someone is now offering you investment advice. They previously were not in that role. They're offering you a deal that's too good to be true. An investment opportunity, or a dream opportunity that you'll give them some money, they'll turn it into, a 50% return within a couple months, and they'll put the money back, no harm, no foul. You have plenty of money in the bank, don't worry about it. Or as we talked about earlier, a claim that an individual has won a prize or a lottery, but that they have to pay taxes or fees before the money will be delivered. We unfortunately do see this. We have had clients of ours that have unfortunately fallen into this scam and this exploitation in the past, and literally have been requested to send cash inside the pages of magazines and newspapers to individuals in different states, individuals outside of the country. And they believe that they're doing the right thing. They believe that they're going to get something in return, or they believe that they are helping someone by sending this money. But in reality, they're getting nothing back. They're just getting a manipulator. They're being exploited. And at the end of the day, they've sent now cash, and it's very, very hard for us to track or try to recover that money. So a stranger has quickly become a close friend. Our hypothetical kind of touched on this, that, you know, someone in rehab, someone in church strikes up a relationship shortly after the passing of an individual, or a traumatic event, or a medical complication that would leave them susceptible, whether it be emotional, physically, or both, to a new relationship being struck up, and that individual showing a new and increased interests in the individual, presumably who has more money than them. We often see older individuals suddenly marrying a new friend or another individual. The ability to make decisions and poor decisions, or bad decisions, if you want to call them, remains with everyone until they are deemed by a court or by a physician that they lack capacity. So what we often say is anyone with capacity can make bad decisions. That's up to you. However, once it's under the scrutiny of a doctor or a judge, it's going to be run through with a fine-tooth comb. If the case ends up in guardianship and someone is found to be disabled under the law, one of the rights that is taken away is the right to contract, including the right to get married. So if you have the ability, you know, if you talk to Adult Protective Services, or you talk to an attorney who specializes in this field, and you get into court and you raise this issue and a guardianship is established, it then prohibits that individual from marrying someone else, and then that individual saying, well, we're married, I'm entitled to certain assets under the law. So requests for personal information. This comes up again with, unfortunately, very high regularity. Personal information, Social Security, pensions, bank accounts, investment accounts. When someone is all of a sudden interested in where your money comes from, who is the payee, who is the representative of your money, how is it being held, how is it being titled, if there are beneficiaries, can we see that? Those are all red flags for us that this person probably does not have your best interest at heart. A common fact pattern we see is that, you know, adult children or adult grandchildren get very interested in mom, dad, or grandma or grandpa's assets and start asking for this type of information. And then what we see is that they go ahead, once they have this information in their possession, they go ahead and make the changes to beneficiaries or to title of a home or to a bank account and add themselves on it. Now, they may do it because they don't think mom, dad, grandma, grandpa has the ability to do that. But more often than not, they do it so that they are then the beneficiaries of the money when the individual passes away. The last item on here is personal possessions. And this typically plays out when either an individual moves to an assisted living facility, a nursing home, or another location. And they leave their longtime home, they leave some stuff behind, and then it's no longer there when they go to get it. Or that they're suffering from some type of cognitive impairment now, and someone is preying on that and just taking items of value from the home during their lifetime. And the fact pattern again is, you know, they take an expensive piece of glass or expensive piece of art or expensive piece of jewelry, and when they're questioned about it, they just simply say, oh, you don't remember, but you gave that to me. And then the person is almost embarrassed to say, oh, I don't remember that I gave that to you, or I don't recall that I gave that to you, or, you know, are you sure? and they don't want to have that conversation with family. So, when these red flags come up that things are disappearing from the home, or that they don't have a recollection of giving that away, the time has come to make an inquiry as to their ability to manage their own affairs. Doesn't need to go to court, doesn't need to go to Adult Protective Services. Does the power of attorney need to step in at that point? Or what can be done to protect that individual?
We have a question.
Sure.
Elizabeth says, our house is under the irrevocable trust. The surviving spouse can't sell the house without my son's permission. Can a girlfriend or lover take out the money or home equity or any way without the son's permission?
There's a lot to unfold in that question. It depends on the nature of the trust. If something is put in an irrevocable trust, obviously the trustee is turning everything over to the nominated beneficiaries of the document. The trust document itself would have to identify if money can be taken out, if the property ownership interest can be segregated, if it can be refinanced. So there's really not a clear-cut answer other than, you would probably want an attorney to review that irrevocable trust document to see what the ability of the multiple beneficiaries are in real time. So the next document is entitled the loan documents and legal papers. Again, these are big red flags for us when new documents are drafted. In the example we talked about with Charlie and the physical therapist, powers of attorney were drafted, estate planning documents were drafted, new wills and trusts. That's taking it to the extreme. What we see on a more superficial level, if you'll call it that, is someone being asked to co-sign a loan, co-sign a car loan, co-sign a refinance to a home. And with high frequency, the refinance to the home is a home that has already been paid off. So someone has been living in the home for years. They have no debt. It's a viable asset. It makes part of their net worth. And someone is now asking them to refinance the home and increase debt they never had to take out. I had this phone call actually yesterday, which the caller said, my brother got my mom, who has dementia, to refinance her house. She now is in default with the bank, and the home was paid off 15 years ago. And of course, mom doesn't have the money. Brother took the money, saying he needed it, but he never then made any payments to the bank. And now mom is on the hook for putting this money back. So that's kind of, the first layer. The next layer is when people get a little bolder, as our hypothetical showed, they're taking someone to a lawyer to sign these documents, whether it be a power of attorney, whether it be a change in deed, whether it be a new trust, or whether it be a change in beneficiary forms. There is a higher standard for the execution of these documents, depending on what you want to accomplish. So for a will, we have testamentary capacity, which is that you have this moment of clarity under the law that at this point in time, you knew who your children were, you knew who your family was, you knew what your assets were, and that you could formulate a plan in your mind as to how the distribution of these assets went. It sounds like a high standard. It's actually a very low standard. In terms of the execution of powers of attorney for property, the standard is somewhat higher. We usually refer to it as contractual capacity. That because you are giving your agent the authority to bind you and your finances, that we need to have a higher threshold here, and that the ability of that person is going to be evaluated more, I guess, in depth than for a will or for a trust. The last thing that is very important on this page is the changes to beneficiaries. We live in an electronic world, as evidenced by our meeting today. Quite often, banks, brokerage firms, financial firms will accept change of beneficiary forms via email, via fax, via scan. You download the document at your home, you sign the document, you indicate if you want to change a person, if you want to change the percentages that the person receives, and you submit that document to the financial institution. And if the financial institution has no reason to doubt the authenticity of the signature on it, or if they do it online, the change itself, that is the new beneficiary. And there are no shortage of those cases being litigated in the circuit court or by our office at this point in time. Again, a bank that you might not be going into doesn't know your cognitive impairments, doesn't know if this is what you want. And this is a very common scheme, an exploitation scheme, in which people are making these changes and then no one's going to find out about it until the individual is either disabled or, more commonly, the individual passes away, and then people go to collect the money and they say, wait, I was the beneficiary 2 years ago and now it's someone completely different. So that case is going to end up in courts, and that's a case, where we want to be able to protect the individual when any of those red flags come up. Do we have someone in place that can make sure that all these assets are locked up, that they're secure, that the change of beneficiary or a new will or a new trust is not going to take place? Lauren, were there any questions popping up?
We do. We have one from Bob. He said, you recommended contacting the Senior Center Adult Protective Services if one has suspicion of abuse. Isn't there an elder abuse hotline of the state, like there is a child abuse hotline?
The answer is yes. The state you can call for the same reason. The way that the state is broken up is that there are 13 areas on aging or divisions on aging throughout the state of Illinois. The state essentially delegates authority to those 13 areas, and then those 13 areas on aging delegate authority further down. So in Cook County, we have the North Shore Senior Center, we have Catholic Charities, and we have a few others that are, I think, the predominant ones who would act as the Adult Protective Services. You can call the state, but as they do delegate down, it would make sense to reach out to the one agency in your local community who is going to be probably better equipped to handle the individual. They may be more familiar with the circumstances, the people in the neighborhood. Maybe they've had interactions in the past. So I think that's probably a safer bet there. So tips to stay safe. We'll go through this briefly just so we can touch on guardianship as well. You want to protect your personal information. You don't want to give this out freely. Banks often say, we're not going to ask you for this information. No one's ever going to call and say, give me your social security number, give me your bank account number. Just like Medicare is not going to ask you for that information. Don't be intimidated by pushy marketing callers or pushy family members. If someone is pushing too far and you feel uncomfortable, the answer is just no. And with family, it's much tougher to say no, but that has to happen. If you can't say no, then, after the conversation, if you're forced into something, you want to go talk to the senior center, a lawyer, your banker, or someone else who can help you out and kind of put a stop or start an investigation to what's going on. And if it sounds too good to be true, it probably is. We run into the situations of people being exploited, money being sent out of the country, which is difficult to get back in. And if someone's telling you that this is the best opportunity of your life, it's probably not. So, Lauren, if we could flip to temporary guardianship really quickly, as we're running out of time. As Kerry alluded to earlier, if we've identified a situation in which we believe someone is being exploited, and we need immediate relief, we can file what's called a temporary guardianship, in which we're going to file a petition with the circuit court of a county, Lake County, Will County, DuPage, wherever that individual may be, asserting that this is an emergency and that we need to go before the court within the next handful of days and have a lawyer appointed either for the respondent or a guardian ad litem appointed for the respondent, and so that the judge can then make a decision as to whether a temporary guardian needs to be appointed. As Kerry said earlier, with any court filing, we need a medical report that has been executed within the last 90 days that will support the individual's inability to make either financial or personal decisions. The judge here is not in a position to weigh the medical evidence, but they are in a position to make two findings here. One, based on the medical evidence that has been given to them, are they disabled? And they are going to just look at the doctor's report, look at the report of the court-appointed attorney or the guardian ad litem and say, yes, a doctor has concluded that this individual is disabled and needs a guardian. The second inquiry and decision they're going to make is, okay, now that we've determined a guardian is necessary, who is the appropriate party to be that guardian? And that the second inquiry is where we get a lot of litigation. There's often competing interests and competing parties, whether it be mom, dad, mom against their kids, grandparents, cousins. That is where we see the fighting and the mudslinging taking place. So on the next page, we have briefly powers of attorney, and we would always recommend that powers of attorney be put in place to try to avoid a guardianship situation. I know we're running out of time here, as I see two on the screen. So all I would say is, in terms of the power of attorney and guardianship, if a valid power of attorney exists under Illinois law, a guardianship case is not necessary. So the takeaway is we have estate planning tools that can prevent the exploitation, assuming it's the right person, someone you trust. If that doesn't work, we have APS, we have lawyers. If the red flag is raised, these are the entities that you should reach out to who can provide you with some immediate relief. And I will leave it at that for the moment.
Well, I don't see anyone else waving their hands. I just want to say thank you again to Brandon and Kerry and Lauren for the slideshow. Very, very nice. Thank you.